to the last of our 3-session legal course. I'm very pleased that you're all with us once again this evening. I will begin with our Devar Torah, and then I will make an introduction of our guest speaker this evening, Attorney Mark Weinberg. My Devar Torah is as follows. One of our Torah's most profound teachings, in my view, involves the great sin surrounding idle gossip of others. And while our Torah, of course, focuses on this arguably most serious sin among our fellow Jews, this important concept, I believe, should equally apply to us all. For me, a natural extension of this Torah prohibition is that we should also actively and purposefully support others, and to do so as selflessly as possible, for doing so is always a great mitzvah. We're very pleased this evening to have Mark Weinberg join us as our guest speaker. Mark is a 1984 graduate of Yale College and a 1988 graduate of the law school at the University of Chicago. Since 2001, Mark has been in solo practice with a focus on civil rights law. Since 2014, his main professional focus has been litigating the constitutionality of laws and policies directed at people convicted of sex offenses. Mark is widely regarded as an expert in the area of sex offense law and policy and regularly consults with criminal defense and civil rights attorneys throughout the country regarding such issues. With that, I turn the table over to Mark. Mark, welcome. We're so happy to have you this evening.
Thank you very much, David. Thanks everybody for being here. I'm really honored to be here. And share with you the work that I've been doing for the last 11 years of my life. I've basically devoted those 11 years to challenging restrictions that are imposed upon people that have been convicted of sex offenses. And I've been doing it with a young woman, younger than I am. She's 40 years old. And so I usually talk about our work, and her name is Adele Nicholas. Together, we're doing work in Wisconsin, Illinois, and Minnesota, challenging various laws in those respective states. When David asked me to speak, I said, well, what do you want me to talk about? Do you want me to talk about, and I have some notes here, do you want me to talk about the situation of sex offenders on parole? Do you want me to talk about parole in general? Do you want me to talk about some of my lawsuits? Do you want me to tell people how I think they should navigate or should be able to successfully navigate through parole? And he said, yes, all of those things. In fact, I'm gonna mostly focus on the lawsuits that Adele and I have done over the course of the last 10 years. And they, I think in the aggregate, say everything that I have to say about the system of parole in our society, which is an extremely broken system, I believe. Parole, for the most part, sets people up to fail. Parole is sort of a no man's land in terms of the law. And by that, I mean that the courts generally have a hands-off approach to the parole system. They think that they shouldn't be interfering with the parole system. The public generally thinks that if somebody's on parole, they're out of prison and everything's great because they're on parole and they should just be happy that they're out of prison. And so there's sort of been a hands-off policy, which has resulted, I think, in a lot of abuses in the system. And some of my lawsuits that I'm going to talk about tonight and future lawsuits that I hope to bring, I think, exemplify the problems with the system. I did want to mention that parole used to be much better. Parole actually started in the 1920s in the United States. It was brought over from Australia, and it was brought over by progressive women who thought that there should be a process whereby people were reintegrated into the community. And so initially parole had this very progressive and helpful notion associated with it of getting people back onto their feet and allowing people to have second chances, if you will. But parole took a horrible turn in the 70s and 80s in our country, and it became much more about law enforcement and much more about public safety as opposed to helping people reintegrate into society. And it's a very interesting question why it took such a harsh turn, and especially in the 80s. But that's been the nature of parole ever since, and it's more about controlling people than it is about helping people reintegrate into society. Okay, which brings me to some of my lawsuits. I have an outline that I want to put up on the screen to talk you through them. Let's see if this works. Okay, so this is broken down into three different parts. First, I wanted to talk to you guys about the lawsuits that Adele and I have recently completed and won, and that's been about getting people out of prison in the first place. Secondly, I wanted to talk about some of our ongoing lawsuits about parole or conditions of parole. And then third, I wanted to share with you a list of potential future lawsuits that we're hoping to bring. But one of the major things that Adele and I have been devoted to over the last 10 years is the problem of people not even being able to get out of prison. And this again is all about people who've been convicted of sex offenses. And the reason people can't get out of prison, or for the longest time in Illinois could not get out of prison, is that they couldn't find compliant housing. And that's because of the laws in Illinois and throughout the rest of the United States that prohibit people that have been convicted of sex offenses from living within a certain distance of a so-called prohibited location. In Illinois, as I'm sure many of you know, people have been convicted of sex offenses can't live within 500 feet of a park, a daycare, or a school. And as a result, people who couldn't find compliant housing for the last decade or so, up until about a year ago when we won our lawsuits, were stuck in prison past their out dates. One person was in prison for 9 years past his out date. That has all been resolved thanks to this first lawsuit that we brought called Murphy versus Jeffries. All of our lawsuits, as you'll see, are against this guy named Rob Jeffries. That he's just the head of the Illinois Department of Corrections. And so as the director of the Department of Corrections, we name him as the defendant. But really it's against the state of Illinois that controls and operates the Department of Corrections. And he just is the head of that department. In any case, we brought a lawsuit. This is already 5 or 6 years ago, that it took like 5 or 6 years to win. But basically we challenged the constitutionality of the policy in the state of Illinois of holding people in prison past their out date. We won that lawsuit. The judge, among other things, the judge called it cruel and unusual punishment and in violation of the 8th Amendment. And as a result, the Illinois Department of Corrections has instituted what they call the Intensive Community Reintegration Program, ICRP. And that just requires the state of Illinois to pay for people to live in housing in order for them to have a place to live once they're after their out date in prison. Maybe I should stop just to make clear that in Illinois, everybody who's convicted of a felony gets 2 sentences. They get a prison sentence, and then they get what's called a mandatory supervised release sentence, which is the MSR, what I'm referring to when I say MSR. And that is sometimes called parole, but it's not really parole, because parole was abandoned in Illinois in 1978, I think. And parole was just when you let people out of prison early from their prison sentence, kind of that came at the good graces of the prison system itself, of the Department of Corrections. MSR is a separate sentence. You get your prison time and then you get your separate MSR time. Anyway, there's different types of MSR. One is called 3 to life. That's an indeterminate term of MSR. They can keep you on it for the rest of life, or they can let you off after 3 years, totally at their discretion, depending on whether they think you're a danger to the community. In any case, people who had a 3 to life for MSR term, literally, unless they had compliant housing, would be forced to stay in prison for the rest of their lives. In response to our lawsuit, that's no longer the case. Our second lawsuit was central to the first lawsuit, and it was called Barnes v. Jeffries, because there was another law in Illinois which severely restricted where people who had been convicted of sex offenses could go. And that was, there was a law that said that a sex offender could not live in a building where there was another person who had been convicted of a sex offense, which meant if there was a 300-unit apartment building, only one person convicted of sex offense could live in that whole apartment complex. And this obviously severely restricted where people in this situation could live. And we brought a lawsuit challenging the constitutionality of that one per address statute, and that was found unconstitutional. And then our third lawsuit about getting people out of prison was actually only last week did the IDOC, the Illinois Department of Corrections, abandon their appeal of this lawsuit. And so now it's definitely official that people who have determinate MSR sentences. So Murphy v. Jeffries up here was about 3 to life sentences. That's an indeterminate MSR sentence. But people who got determinate MSR sentences also were forced to serve out their MSR sentences in prison unless they had compliant housing. The IDOC agreed that they would not force that population of people to stay in prison. Okay, that's that's a big part of the work that Adele and I have been doing over the last 4 or 5 years in this area. And I was talking to Rabbi Scheinman actually last week, and he told me that other speakers like Alan Mills, the distinguished lawyer who does a lot of work on prison litigation, was kind of lamenting over the fact that a lot of his lawsuits haven't had the lasting effects that he's hoped they would have. And I guess, I understand that the IDOC is an institution that is very reluctant to change, but Adele and I are very proud of the fact that it seems like we know we've gotten like 900 people out of prison who otherwise would be sitting in prison. And the IDOC has instituted this new program, which has changed people's lives. And so that's the good news. We're getting people out of prison. The bad news then is what happens after people get out of prison, because the parole system is just awful. And we are now in the process of challenging a bunch of lawsuits about parole conditions. The two ongoing ones are these cases, Frazier v. Jeffries and Tucker v. Jeffries. And one challenges a policy in the on parole where anybody who's been convicted of a sex offense can't have contact with a minor, including their own minor children. Adele and I brought this lawsuit. We had a trial in April of this year, and basically we lost the trial. That is, the judge, it was a judge trial, no jury of our peers, just the judge decided the case. It was a 3-day long trial, and all the experts from the IDOC talked about why people who've been convicted of sex offenses, even people who've never touched a child, meaning mostly people that have looked at child pornography, should not be allowed to have contact with their minor children as long as they are on parole. We are now in the process of appealing that decision. The one part of the lawsuit that we did win is the judge said that when they say no contact, they mean no contact in written communication, telephonic communication, or face-to-face, contact. And the judge did say, well, they should be able to have written communication, but that's the limits of their rights. The second lawsuit that we're challenging involves the internet policies of the IDOC for people who have been convicted of sex offenses on parole. And it's a kind of a complicated policy. They say that for people whose crimes were related to the internet, the sex offender therapist should have the power to deny parole, to deny internet access while people are on parole. And for people whose crimes were not related to the internet, they're all required to have monitoring software, which costs roughly $40 a month, and they can monitor everything people do on their, phones or internet. Anyway, we're challenging that whole scheme. We don't think that people whose crimes were not related to the internet should have to have monitoring software. First of all, a lot of people can't afford it. As I said, it's like $40 a month. And so that just means that they can't have the internet at all if they're required to pay $40 a month for it. And second of all, both of these lawsuits challenge the idea that these sex offender therapists should have the authority to make determinations about people's constitutional rights. In the case of Frazier v. Jeffries, that constitutional right involves one's contact with one's own minor children, which parent-child contact has a well-established protections under the Constitution. And then the internet policy raises serious First Amendment freedom of speech concerns. And we don't think that these treatment providers have the capacity and knowledge to make determinations about constitutional rights. Okay, I know I've talked way too much already, but I can talk about future lawsuits that we're planning to bring, because as I say, parole is so, they make parole so difficult. There's just so many things that we want to challenge on constitutional grounds. But before I do, I don't know if I should open the floor for questions. Mike, do you have a thought about that? Should I continue, or should I ask questions? Should they open the door for questions?
Well, Mark, if anyone would like to ask a question, please just raise your hand, or you can text me or David.
Yeah, I think it's a great idea to open the floor to questions now. We can continue, Mark, with your outline after we get through some of the initial questions. I see some hands raised. Why don't we begin that way?
Okay, let me take this off the screen then. Stop share.
Okay, we're good now. Perfect. Carlene, you want to assist with calling upon those who have questions?
But but it's a serious problem. That is, we can get a judge to order or hold something to be unconstitutional, but then having it implemented by the Department of Corrections is a whole nother problem. They have to train their parole agents. They have to train their, field services people. And so, yeah, all these changes take time, first to win the right, and then second to have them adequately implemented. In this case, though, REA, I think that they are allowing people, well, not only are they allowing people to be released to places where there's multiple people convicted of sex offenses live, but they have their own houses now where they're placing people. So they wouldn't be able to have this ICRP program without the ability to put multiple people convicted of sex offenses in one building. Okay, well, it's been very interesting working, as you put it, across state lines, because every state is bad in its own way. Wisconsin is bad in several ways. And by bad, I mean much worse than Illinois. So the two ways in which Wisconsin is really bad is that Wisconsin allows every one of its municipalities to pass its own residency restriction laws. In Illinois, in contrast, the residency restriction laws are passed by the state of Illinois. So every municipality has to follow the state of Illinois' laws, and they can't create their own laws. So in Illinois, as mentioned, there's a 500-foot requirement that people can't live within a park, a school, or a daycare. In contrast, the 170 different municipalities in Wisconsin all have their own rules, and there's a race to the bottom to impose residency restrictions. And we have been challenging some of the worst residency restrictions that are imposed in these municipalities, including what I think is probably the worst one, which is in a place called Paris, Wisconsin, believe it or not. They have their residency restrictions are twofold. A person convicted of a sex offense can't live within 6,500 feet of an array of prohibited locations. The prohibited locations include things like golf courses and libraries, and trails, and the law in Wisconsin prohibits one person convicted of a sex offense from living within 6,500 feet, a mile and a quarter, of another person who's been convicted of a sex offense. Anyway, Steve, numero uno, one problem in Wisconsin are these residency restrictions laws, which make it almost impossible for people to live in many of the municipalities in Wisconsin. The second big problem in Wisconsin that's much worse than Illinois, and that we have a lawsuit about, and have since, it's been lingering for 4 years and been up and down to the appellate court, Seventh Circuit Appellate Court, but is the GPS restriction in Wisconsin. The GPS restriction in Wisconsin, believe it or not, says anybody that's been convicted of certain types of sex offenses has to wear a GPS for the rest of their lives, even after they're out of prison, after they're off of any criminal supervision. And this is, we believe, a violation of the Fourth Amendment of the United States Constitution. The Fourth Amendment prohibits unreasonable search and seizures. And this is an unreasonable search because it is recording where a person goes there. One is like a private nursing home, and the other is a nursing home with that for public that gives public aid or is subsidized by the government. Because as far as the first, I think private nursing homes have total discretion, of who they admit. Obviously separate and apart from, they can't discriminate based on race, gender, or religion. Those are statutorily, prohibited means of discriminating, but they're allowed to discriminate based on a criminal record. And they don't have to take felons, for example. Then there's the separate issue of government subsidized nursing homes. And this is even more heartbreaking because there are laws that prohibit people that have been convicted of sex offenses from being admitted to those nursing homes. And I don't know what to do about that. I don't know if there's a constitutional challenge there. It breaks my heart to say that. It breaks my heart. This whole issue about elderly people and nursing homes is a very, very sad situation. So I don't have any good answers. And I don't know. Yeah, I don't know what to do. We've been thinking about this for several years now. We don't have a good legal theory for bringing a lawsuit. There's no constitutional right to be admitted to a nursing home. There's a constitutional right of, there's lots of constitutional rights, free speech and against, unreasonable search and seizures. But there's no right, for example, to even be able to have a home, to live in a particular place. The residency restrictions lawsuits create some interesting, legal problems too in that area, because there's no right to be able to live in a particular community or in a particular home or near a park. Now we're able to get around some of those legal problems by suggesting that this imposes punishment in a way that violates the ex post facto clause, which is in the Constitution. But I don't want to get in the weeds of the ex post facto clause. But suffice it to say, Beth, I don't have a good legal theory. We can't figure out how to challenge this scheme where people are prohibited from these nursing homes. But we're going to continue to think about it.
So do people have a constitutional right to health care?
Well, I think have a potential success, for success. So this is the first problem in Illinois is that I told you, right? Everybody gets an MSR sentence. Some MSR sentences are for 3 to life, which is an indeterminate sentence. Some people, depending on the crime you committed, get a determinate sentence of 1, 2, or 3 years of MSR. Well, when you have a determinate sentence, there's a deadline when you get off of MSR. But when you have a 3 to life indeterminate sentence, there's no clear criteria of who gets off of MSR and who doesn't. And we want to bring a lawsuit saying that lack of clarity violates the due process clause, which is to say it's totally arbitrary, it seems, who's getting off of parole and who's forced to stay on parole for years past their 3 years. Anyway, that's one lawsuit. Another problem with MSR, with the MSR in Illinois, and I know I've talked to people who are on this call about this lawsuit, is that there's no way to really effectively appeal a parole officer's decision. So in many cases, we've heard of parole officers who have told people that they can't work in a particular field. One friend of mine is a truck driver, and he had to drive his truck to Missouri, I think, on occasion. And the parole officer, just on a day basis, not stay overnight or anything, just in the course of his drop-offs, he had to drop something off in Missouri, or Iowa, I forget. But the parole officer said, nope, I'm not going to allow you to go out of state. And because he couldn't do that particular run, he lost that job. In any case, it's a serious problem that there's no effective means to appeal these decisions. And we think the lack of an appeals process is ripe for a constitutional due process challenge. The third lawsuit that we'd like to bring is that people, when they are revoked in Illinois, get an automatic 2-year prison sentence for their revocation. And we think that's extreme for getting revoked for what amounts to just like not a violation of any law, but just like a rule of parole. So if somebody was late or failed to meet their curfew, they can be sent to prison, and sometimes are, for 2 years. And we think that violates the cruel and unusual punishment, the Eighth Amendment, which prohibits cruel and unusual punishment. A fourth lawsuit that we want to bring has to do with the whole revocation of one's parole, because these hearings, I don't know if anybody out there has experienced them, but they're basically jokes. They're kangaroo courts. There's no real due process associated with them. People are revoked based on the mere reports of parole agents who don't even appear at these hearings. And there's no real good way to, there's no integrity to the evidence that is presented against people. And we want to upgrade the due process requirements associated with these revocation hearings. The fifth lawsuit that we want to bring is the GPS requirement in Illinois. Now, I mentioned that Wisconsin's even worse, and they have this GPS requirement whereby people who've been convicted of certain sex offenses are required to wear GPS for life, even after their parole. But in Illinois, everybody who's on parole for a sex offense has to wear a GPS. And this seems to me extreme and excessive and unduly punitive. And we want to challenge that, but we're not going to challenge that until we win the Wisconsin lawsuit, because if we can't win a lawsuit about people having to wear GPS for life even after they're off of supervision, we're not going to win a lawsuit against the state when they're on supervision. And the sixth lawsuit that we're definitely going to bring,
Mark,
this is.
can I pause you there for just a moment? It looks like Isaac had a question. Isaac, did you want to ask your question?
Hi, Mark.
Yeah, so it would only apply to people that were convicted of who have a sentence of 3 to life, Isaac, because if a 3 to life MSR, because if you're, okay, so let's say you're you have a 3-year MSR sentence, then usually when you get and that sentence sometimes is either at 50% or 85%. So when
I'm well versed, Mark.
Okay, yeah. So yeah, if you're well versed, good. I'm not sure everybody else is, but when you serve your sentence in prison on MSR, you get your reduction in time for doing it in prison. Suffice to say that the 2-year automatic really isn't applicable to people that have determinate sentences, as opposed to people that have indeterminate sentences, 3 to life, that is. And they get no credit, people who have been revoked, who do their time, who do 2 years, they get no credit for that time they do inside. they have to do 3 years outside at the very minimum. And they have to do it continuously. So if you do a year and a half and then get revoked and do 2 years inside, you then have to come back out and do 3 years at a minimum outside. It's, again, it's horrible and punitive and excessive and extreme. I don't know if, did I answer your question? Yeah, no, that's a great point. No, it's true that some states are better than others. Kansas, for example, is the only state that doesn't have any residency restrictions imposed upon people that have been convicted of sex offenses. From this top down, the state of Kansas says no municipality is permitted to impose residency restrictions. And if you go to their website, the state of Kansas website, they have a whole explanation for why these residency restrictions have no validity, and all the evidence, the scholarly evidence, shows that they do nothing to protect public safety. And this is, of course, part of our arguments and our challenges to Wisconsin's residency restrictions, which is that there is just no good reason that that these residency restrictions have any validity. Thank you. That means so much. And of course, I wish you well, and I look forward to hearing about all your successes in New Mexico.
Okay, I'll sell you some Southwestern food.
Welcome visit.
Okay,
It's probably naive, Mark, because I come from Canada where we don't have a registry. But is there any way of protecting the rights of people on the registry in terms of employment and housing? Like, once they get the housing, can they be discriminated against if they've met all the criteria? Once they have employment, can a person decide to fire them? Is that permitted, or is that considered discrimination?
Okay, so let's take the housing. If I'm understanding you correctly, let's start with the housing, which is to say, if a person has a house in a compliant location and a daycare moves in, that person in Illinois has to leave, has 30 days. Actually, only because of the grace of the police department do they get 30 days. Under the law, they have to move immediately. There's no grandfather clause, so they can be discriminated against even if they lived completely legally, and a daycare or a school or a park moves in. There's something called pocket parks, and it's actually in one of the communities in Illinois, Joliet. In order to get rid of a group home where there's 6 people who've been convicted of sex offenses, all of whom are on parole, the city of Joliet has built a little mini park so that all those people have to move now from their location. And so, this is one of the ways municipalities, one of the games that they play. But okay, so then your second question about employment.
Well, so let's say you rent and you've met all your conditions, and then the landlord after decides that he's going to evict you. Can he do that?
Yeah, I think landlords have he can't violate your contract, your lease agreement, but he could definitely decide that he doesn't want a felon living in his apartment. There's very little protections for felons in the law. Privately, in terms of private companies or entities deciding whether they want to deal with you or not.
Although, Mark, have there not been changes in Cook County with respect to felons in housing? I thought there was, actually, the ability to use the felony conviction to prohibit housing in Cook County. I know that we had a guest speaker that worked with Alan Mills, who was working in Alan's office, who spoke to that issue last year with the law change.
Yeah, that could be. I actually am not, I'm gonna plead the fifth on that one. I'm not sure exactly what's going on in Cook County in that area. And of course, there are some laws about employment rights too in felons. They're not allowed to ask whether you are a felon,
Right.
but they are able to take it into consideration after they offer you the job, I think. It's very complicated and administratively a little bit fuzzy, and certainly in my mind, it's fuzzy.
Actually, I do recall it, the exclusion on the, more flexible approach on the Cook County change in the law does not apply to those with sex offenses. That's an exclusion, and so they can use those, convictions, to prohibit, you from being able to become sign a lease of that particular apartment rental.
Yeah, as a general matter, these carve outs,
There's
you
a
know,
couple.
are a serious problem. People, the sex offender exception, they're treated worse than any population of people in our society.
I think Al has a question, then Michael.
Al Goldberg. Nice to
Al,
see you got no, Mike, you got a question?
Yeah, thanks. Mr. Weber, I just want to thank you for being here and relaying this information. While most people here are in or around the greater Chicago area, some of us are not. And I'm wondering if you could speak to, if you have any sense of the broader direction that the nation is going. For example, other states, or more particularly federal law, and whether you have any indications of that changing in terms of the severity of the impositions currently extant.
Wow. Okay. So I do think that we are in a long-term struggle here. And I think that, like any struggle, there's going to be ups and downs. A struggle like civil rights struggle. This is a struggle for justice for a certain population of people. And I think the struggle is going to continue beyond all of our lives. And I actually, find great meaning in, like in being part of a community that is struggling, like all of us, to correct some of these injustices. But I'm not a rah-rah guy. Nothing's going to happen in the next, 5 years that's going to be great. It's going to get better over time. All the scholarship is on our side, but the fears and prejudices of the population at large are against us. And of course, this raises philosophical questions about why sex offenders, are this targeted group worse than any other, treated worse than any other group. And anyway, so I want to say this is a long-term struggle, and things are gonna get better, but it's not gonna happen soon.
Thank you.
What do you think?
What do I think? I think a lot of it derives from timing. I mean, so you had the Me Too movement, you had all the sex scandals, Catholic Church, Boy Scouts, etc., athletic coaches, which kind of all erupted at the same time. And it was covering up years and decades, even of actual and quite serious abuses of varying degrees, some targeted children, women, whomever. There is a legacy of the abuses of power in this country, and that's clear. And that's, you can look at Mad Men, to see some examples, for example. The overstepping, in other words, there was this huge national cry about these injustices, and then politicians realized they could make traction, and they could gain leverage by using this issue by promoting ever harsher and more comprehensive policies. So that is one issue. Another is that we're living in an era where social credit is kind of a thing now. I mean, you start with your credit score, for example, but many things can be and are being measured. China measures how your children do in school and then uses that among many other indications, or if you spit on the sidewalk on live TV, to determine if you can get a hotel room or use an airplane to get from one place to another, etc. So, sex offenders are a test run to see what other impositions I think may be placed on other categories. It's just the easy one right now. I think
Yeah.
both of those things are true in tandem.
Yeah. Yeah, thank you. That's very interesting. Isaac? Oh no. Who? Somebody else got a question? Know what the benefit really of getting sex offender therapy in prison is. I'm a little confused by that because everybody who gets out has to take sex offender therapy anyway. So it's not like you get credit or anything for doing it inside. Whereas in other places like Wisconsin, in this sense, I think Wisconsin is better. You actually do, it alters your parole conditions, or can, if you take sex offender treatment therapy in prison in Wisconsin. But I haven't seen that to be the case in Illinois. Anybody else have comments about that? No. So I don't know exactly why, I don't think it matters if he takes sex offender treatment, but maybe I'm missing something. Like, in fact, if I would like to talk to him, he should call me, have her give him my number so I can find out where he's at and why he wants to take sex offender treatment in prison.
Well, he doesn't want to have to move in order to do it because he's already kind of got a good situation where he's at.
Yeah,
And
so
he's
but
just,
why would he want to? Yeah, why would he even? Okay, what would be the benefit of even if he doesn't want to move? What would be the benefit of taking it in prison?
I don't, some people seem to think that you get good time for it.
Yeah, I don't. Okay, that is possible. But all I'm hearing is that sex offenders are not getting good time, even if they take it.
Yeah. Yeah, that's very cloudy, very cloudy.
Yeah.
Whether,
A lot about it. I don't know if you're familiar with the case that was brought by Janice Belushi in California. I have the case on my computer. So the case was a very good decision by the judge, who said that the conflict between state and federal requirements here is irrational and violates due process. And the federal government cannot prosecute people if those individuals cannot properly register in the state. And call me tomorrow, Isaac, and I will forward you that case, and you can read it and we'll talk about it. You guys, can I give you guys my email? I don't know if it's mweinberg@sbcglobal.net. Anybody wants to contact me. Only other thing is this, we are interested, we're gonna do this, what we call the big one, which is a challenge to the Illinois registration scheme. And that's because these schemes have become so punitive that they violate the ex post facto clause under the United States Constitution. And they've become so punitive because these registration schemes, as you all well know, not only require you to register, but they prohibit, where you can be. There's location prohibitions, there's residency prohibitions, there's these registration schemes are now lifetime. When the registration schemes were upheld in 2003 in a case by the United States Supreme Court called Alaska v. Doe, the registration schemes were nothing like this. There was only a registration requirement. They didn't impose all these other peripheral restrictions, or not peripheral, but concomitant restrictions. And so they've become, it's ripe now to say that these schemes have gotten extreme and excessive, and we want to challenge this in Illinois. There's a big challenge by the ACLU in Michigan, and we want to model our challenge in Illinois against theirs, and that includes hiring in Michigan, they've hired the 3 premier scholars in the country on these issues of recidivism rates, and the validity of residency restrictions. And they also have a 3rd expert witness on how the internet has changed everything. In 2003, the internet wasn't what it used to be. But now when somebody's name is posted on the internet, they become the subject of harassment and humiliation, in ways that the Supreme Court never understood or took into consideration. So for those reasons, over the next year, our big challenge is going to be to the Illinois registration scheme. And with that, I'm done. Hey, there's Paul. Hi.
Excuse me,
That's
may
it.
I just ask you something, please?
Hi, go ahead.
Please.
You can't leave. You can't even leave the state. It's hard enough to leave the state. You're not able to leave the country if you're on MSR or probation or supervision. You can leave once you're off of supervision.
And can someone return American citizenship, went
Oh.
out to jurisdiction and leave?
So
Is it possible,
I
theoretically?
don't think renouncing your citizenship would get you off of parole. You'll still be subject to your obligations of having been sentenced.
Wouldn't you get deported?
No, you wouldn't be deported. I mean, okay, so that is an issue. We deal with people that are deported, but those people have come from a country. Like if somebody is an American citizen and they renounce their American citizenship, there's nowhere to deport them to. They don't have a home country to go to.
But the country can be someone who can accept them, means,
Wow. So you're saying if they renounce their citizenship and then some country says, yes, we accept them. I don't know. That's too high level for me. Time registry versus something less for Section 8 housing. Yeah, the problem, of course, in Illinois is that it gets like 85% of people are lifetime registries in Illinois.
At the moment.
I think Carlene also wants to encourage everyone to fill out the course evaluation after the 3 sessions.
Yes, that would be
So
very,
maybe we'll do that, and then you can thank everybody, David, and then we'll open up if anybody wants to stay on.
okay, perfect.
So everybody click on the,
Well, you answered the federal one. I just wanted to make you aware, Mark, that those of us who are residents of Pennsylvania, there's a very big Pennsylvania case that we're cautiously optimistic about called the Torsolari case,
Yeah.
which is a frontal attack on the very existence of SORNA, written by a Chester County suburb of Philadelphia judge, which has now made its way all the way up to the Pennsylvania Supreme Court and will be heard, I believe, in May, finally. And so that's a question of when they decide and how that intersects with whatever the legislature does.
Yeah. It involves irrebuttable presumptions, right, Mike? And just FYI, I've never shared this with anybody before, and I haven't talked to him since we graduated college. But a friend of mine in college was Justice Wecht, who's on the Pennsylvania Supreme Court now, and he has he's written some very good opinions in this area, and I'm proud of him for doing that. And I think I should be inspired to write him a note to say that I'm in this world and am grateful for his thoughtful opinions.
Mark, if I could, I had a question. Earlier, one of our class participants asked in the context of the ability for nursing homes, private or public, to deny entry. And then the question followed in terms of medical care. And you said possibly not a constitutional right. So are we saying in Illinois or elsewhere that if someone had an emergency room needed a hospital, they could be denied entry on that basis, on a sex offense?
I think there are statutes about that. They can't deny emergency medical care to anybody, indigent or, you know, whatever their convictions are. I don't know those offhand, but I know it's about based on ability to pay, they can't deny.
Okay, because I was wondering, I was wondering more broadly if hospitals can deny entry, and I wanted to take the extreme example of an emergency room need. So, okay, I was curious on that one.
But I don't think it's a constitutional right. It's a statutory right.
Gotcha.
Yeah.
Understood. Okay, are there any more questions from anyone at the moment? Any final questions for Mark?
In Illinois, it's been proposed a couple of years in a row now, and it has it would be great if it were passed. It would reduce the 500-foot restriction to 250 foot. It would also put in a grandfather clause, which says that if you know, you live in a compliant place and something moves in, a prohibited location moves in, that you don't have to move. It has a couple of other provisions. It's going nowhere. The truth is that there's a huge political problem, which is that there is no upside for politicians to pass any laws that would benefit, you know, this population or impose some sanity to this world that of, you know, people on the registry. And so I don't think there's any chance for any serious laws to be passed. Politicians would just take too big a hit. They pay too big a price to do that. And so, you know, I mean, I think there is some reason to be hopeful for getting courts to find some of these laws constitutional. And that's where I'm focused. And I hope I'm wrong about the legislatures, but I just don't see it happening anytime soon.
Thank you.
I just want to say a quick thank you.
Yes.
First of all, to David Grosky for putting together this excellent series. I can't tell you how many great phone calls and texts and comments I got about the series. And also to Mike and Carlene for facilitating it. It was really a great job. And Mark, I just want to say out here at Hinda, you're a hero. So we are constantly fighting for housing, for employment with our caseworkers. Hard, and it's nice to know that there are other people fighting out there with us.
Yeah, we're in it together, Beth. Thank you. Thank you.
Yeah.
David, thank you. Thank you, everybody. I really appreciate it. And yeah, like this is my life now. We're all in this fight together.
And Mark, I want to thank you personally for being a part of our panel in the course session list that included, you know, several very, as you know Alan Mills, and he's been a regular with us for 3 years now. We had Elizabeth Kelly, who's real expert on the mental health issues that she spoke to, and you this evening. So it's been a tremendous 3-course session, and we thank you so much and look forward to hopefully having you again next year.
Thank you, David. Yeah, I'm going to watch both Elizabeth and Alan's presentations because I'm really interested to hear what they say.
Please do. We enjoyed that too.
All right, I'm going to say goodnight.
Thank you.